Okay, thank you all for joining us for panel 2. We are moving through our exciting day of coverage of the intersection of foreign investment law, international human rights, international environmental law, and our second panel is going to take a bit of a deeper dive into the foreign investment law side of things. Just wanted to give you a couple of administrative announcements. We are going to transition our book signing event, which was supposed to happen during the coffee break, and we had some delays. So we are going to have that upstairs where we have lunch. So we will be going upstairs after this panel to the FCC, which is on the 5th floor of this building. And the book signing will be available there as we enjoy the lunch and prepare for our keynote presentation starting at 12:45. So without further ado, I'd like to introduce Ian Laird, who is our moderator for panel 2 from Crowell. Ian, the floor is yours.
Well, thanks so much, Dina Bate. It's a real pleasure to be here at GW Law School. GW has a long history of scholarship and teaching in international law, and in particular international arbitration. Some real luminaries in the field of international investment arbitration, or ISDS, which is the common acronym now, have been professors and teachers here, like I guess Stanimir Alexandrov and Judge Charles Brower. So this law school has a great tradition in examining these issues, and one of the most current issues is, of course, the question of the intersection of human rights and the environment. And that has grown to be a very important part of the ISDS discussion and jurisprudence, the case law. Many arbitrations, as we heard in the previous panel, now address environmental issues. And more so, that's, I guess, not unexpected in the sense that many of these cases deal with extractive industries and national resources, and frequently have a political and societal dimension because the nature of those types of investments, and this is about foreign investment. ISDS is investor state dispute settlement. And we talk about investors, we're talking about foreign investors being invited into countries to support the local economies, build businesses. And in particular, in the extractive world, it's clearly one of those industries that has a major impact on the environment, a major impact on society. And perhaps it is not unexpected that we would see some amount of debate about the development of international law and related issues as well that have been brought up in the developing case law. So we have this first panel. That's great. So we have this second panel today, panel 2, it's titled "The Crisis of Investment Arbitration, What Next?" And it really is a continuation of some of the discussion we heard in the first panel. We have a excellent group of panelists who will be addressing that topic. And we have their bios in the program, so you can read all the details. But let me just give a short introduction to let you know what an excellent panel we have here. To my left is Analia Gonzalez, who's a leader at Baker Hostetler here in Washington, D.C., practicing international litigation and arbitration, primarily in Latin America. And she's had a wide range of experience in ISDS, at the ICSID, in UNCITRAL arbitrations, and particularly, as I said, in Latin America. And so I'm really looking forward to hearing about Analia's experience. To my right is Ladon Mehranvar, who is a senior legal researcher for Columbia Center for Sustainable Investment at Columbia Law School. And she focuses her research and teaching on investment law and policy, human rights, and sustainable development. And as you know, the CCSI is one of the leading centers, certainly in the academic world, studying the intersection of human rights and ISDS and all issues related to ISDS. So it's really great to have LaDawn here. She just to mention, she also teaches, I think, at Princeton. And I think most importantly, she is a Canadian, which elevates her, I think, much higher than the normal person. I think you all should know that. I'm as Canadian as well, so this is kind of a given, but just had to mention that. And our yeah, and I'm sorry as well. Yes. And our third speaker, and he is on his way and has been in traffic, is Patrick Pearsall. And Patrick has recently moved to Gibson Dunn, so he and Maria can work together now, which is great for both of them, I'm sure. And Patrick has had a very wide range of experience in the ISDS space. One of his former jobs was working at the State Department. He was the chief of investment arbitration there for many years. He has represented, as all of us have been involved in many cases, he's represented governments and investors, and really has a wide range of experience. And certainly on the issues we're dealing with today, he's developed a considerable expertise. So this is going to be a great panel. I think we're going to try to keep this in kind of more discussion mode, a little, lower on the speeches, although being all teachers in one way or the other and lawyers, it's hard to not give speeches, but we'll attempt to keep this more discussive. But going against my own admonition, I'm going to give a little bit of a speech to start things off. And I think partly this is in recognition that there's some of us here are students and maybe are new to this. And probably, when backing up from the question of, is there a crisis in ISDS, what is ISDS? And I don't want to spend a lot of time on that, but as if you were here for the first panel, you can gather that there is this dispute resolution system, which is developed mainly at the World Bank, like 3 blocks over, through an institution called the International Center for the Settlement of Investment Disputes, ICSID. Many arbitrations also occur under United Nations rules that were promulgated by UNCITRAL. And these arbitrations, for the most part, have existed since the mid-1960s when the ICSID Convention was signed. But really, we've seen a dramatic increase since the late 1990s with the cases under the NAFTA, of which I've spent a good part of my career, as well as the Argentina peso crisis cases in the early 2000s. And from that point, the knowledge and skill set of practitioners and the study of ISDS by academics increased dramatically from that point on. And a lot of this mirrors my career practicing almost exclusively in international arbitration and particularly in investor state arbitration. I was involved in some of the earliest NAFTA cases. And actually, because I know students love stories from their professors, one of my first cases involved a company called SD Myers. And there's a case called SD Myers versus Canada. And our client was a remediator of toxic waste. And this kind of really fits into some of the earlier discussion about some of the, most important elements of the, environmental protection is dealing with toxics. And their companies focus very much on PCBs. Now, you might know that PCBs are one of the most toxic, terrible chemicals. When it gets into the environment, it goes all through the food chain, just appalling. And it was banned in the 1990s, but it was an incredibly useful chemical for insulating transformers, for electrical purposes. But there were millions of gallons of this stuff floating around, and it needed to be remediated. And our client was the leading company in the United States worked for the EPA, had destroyed and remediated a great deal of the PCB waste in the United States. And it sought to do that for Canada as well. Unfortunately, politics intervened, which does happen in Canada. And the Minister of the Environment at the time decided that PCB waste, even though it was all created in the United States, that it should be remediated in Canada, and didn't want the US company to have that business. And there were pretty open examples of discrimination in favor of local Canadian companies, which ultimately led to an award against Canada. And a lot of interesting issues certainly came up in that case, being one of the early environmental cases, about, for example, the discretion of the minister to do what she did. And certainly the concept of non-discrimination and national treatment, which is the standard that was applied, came under a bit of scrutiny, because some would argue that the Canadians should have every right to determine, where this chemical should be destroyed, and that this was, an issue of pure discretion. The tribunal looked at this very closely, of course, and it became very clear, and this was from public statements of the minister, that she was doing this for political purposes, to curry favor in the political environment. And the tribunal was just simply not impressed with that, and ended up giving a decision against them. So I tell this story simply because it's one example that the overlap of ISDS and this type of international dispute resolution has been going on for a long time. And this goes back to some of these earliest cases. We see it continuing today because of the growing need for, and we talked about this before, growing need for investment, foreign investment, doing big extractive projects, whether it's for mining or oil and gas or whatever, take a great deal of private funding. And that intersection, unfortunately, creates disputes. And ISDS is viewed, and historically, as a solution to that, rather than having states fighting amongst themselves and perhaps representing individual private companies in international disputes. The idea was to allow claims to be made directly by those investors rather than making it state to state. And partly this was viewed as a solution to gunboat diplomacy, in which states would, and we've seen a little bit of this in the current environment, threaten other states with annexation unless they gave in to certain commercial demands. And by having a treaty mechanism, the idea was to provide a neutral environment. And we've seen some debate recently, and then I'll transition now into the question of the crisis. We've seen a lot of criticism of the ISDS system, and really from its beginning. And this goes back, and we talked amongst us in the group, and Patrick even remembers this, back to the late 1990s, the OECD proposed a multilateral agreement on investment. But there was a great deal of pushback. There was the battle in Seattle. There was a great deal of pushback on trade, international trade generally, and the Washington Consensus. And we've seen a continued debate and critique of ISDS's role in the international economic system. And I really liked the question that was asked actually at the end of the last panel. And I think this goes really to underline the nature of the crisis, and we'll get to that, is do we really need ISDS? And is it a question of the treaties? Is it a question of the tribunals? And I think these are all valid questions, and certainly academics and folks like us who spend a lot of time talking in conferences like this and amongst each other, these are all issues which have come up repeatedly since the time I started 25 years ago representing parties in these cases and teaching as well. So let's get to the crisis part. So we had Maria, and thank you very much for Maria giving us a nice lead in to some of the topics which we want to talk about. Part of the debate, of course, goes to questions of, the system itself. And this is the question of, is the international commercial arbitration model the correct one? So that's one thing. Another part of it is, are the tribunals themselves equipped to deal with these very, complex issues now dealing with questions of international law that, really weren't on the table 20 years ago, especially when some of these earlier model bilateral investment treaties were actually being drafted. So just to tee all of that up, and I know that was a bit of a speech, let's get to the discussion here, because I think there is kind of moving back, there is a question, is there a crisis? And I think the organizers wanted to kind of stir things up, and there are certainly commentators out there, and Maria was referred to the Boyd report from a year and a half ago, 2 years ago, concerning, the kind of the critique of ISDS and how it's incompatible with human rights and the environment, and that we should just get rid of it. So that's kind of one end of the spectrum. And if you read the report, I think for those students who are looking at this and want to read about it, you can really see an itemization of the various critiques. There are other kind of more middle of the road critiques out there, and we've seen some of our leading arbitrators taking advantage of being given speaking engagements, usually at Global Arbitration Review or at law schools and so forth, to kind of address this crisis issue. And recently, there were two of these arbitrators, leading practitioners. One is a British King's Counsel, Toby Landau, gave a speech, and he very kind of passionately related the I guess confrontational dynamic, as well as the kind of impact you see on local peoples and on the environment, and how that creates an environment in these cases which can be quite controversial. And he, in his critique, suggests that the arbitrators and the arbitral process needs to be adjusted, that the commercial arbitration model is insufficient. Another commentator, the former president of the ICC court, which is the leading international commercial arbitration institution in the world, a gentleman named Alexei Moore, also made a similar speech, and it's very directed to environmental issues. So I do recommend it, as he touches on a lot of the crisis issues. And he also agreed with Toby that, it's maybe not just the process that needs to be adjusted, but that the way the treaties are drafted, the standards that are in them, and how they view, and how they interact with the environmental and human rights sphere, that the better job needs to be done on that. And this is Maria's point about convergence. And I think Alexei Moore would definitely, agree with the idea of convergence. So let's then step back for the panel and get the discussion going. And I'll start with Patrick, since you came last, and you don't know
I've had an
anything
exciting
that I
morning.
said earlier. But is there a crisis? That's the first question, and we'll get to what the answers to the crisis are,
Yeah.
if there is or is not. But how do you view this question? Is there a crisis in ISDS?
Sure. And first, apologies for being late. There was a police action on Connecticut Avenue. So it's never a dull day in DC, and they basically closed the roads for about 30 minutes. So I apologize for being late, but here I am. And I feel a little bit like Brutus or Mark Antony kind of praising Caesar at his death, because I come here not to attack ISDS, for ISDS is an honorable dispute settlement system, right? But then, of course, I'm going to explain how I think crisis undersells where we are in investment treaty arbitration. And I think the future, and we'll get to all of those, I know, Ian, but the future is just taking out the word treaty. I think investment arbitration will persist, but I think arbitration without privity will end. And that's my kind of conclusion, but let me explain first why I think crisis is underselling it. To my mind, and I don't know if you introduced me in absentia, but I used to work at the State Department. I've spent my career mostly representing respondents, so states, in defending their right to regulate. And for the last 10 years, I've been a delegate to the UNCITRAL working group, which is attempting to quote unquote reform ISDS, right? So I've spent my career kind of vindicating, in most instances, these environmental regulations that you're all very concerned about, rightfully so. So with that, crisis. I think that there is no constituency left, really, with the exception of a few users of the system, a few investors, who really want this system. There's no constituency for it in the United States on the left, and there's no constituency for it, really, on the right. In Germany, Hans and Helga, Hans on the left, Helga on the right, also don't like ISDS. The future of ISDS in Europe is they're trying to find ways to repackage it, but there's no constituency really in the world for it anymore. So those of you who are students here, if you want to go into public international law, I encourage you to go into public international law, and ISDS is a component of that perhaps, but that's not what public international law is really. Go into public international law, it's worth it. But if you want to go into investment arbitration, you're going to need to trim your sails away from treaties. So the crisis really is two things, and then I'll cede the floor back. The crisis is the basically abject collapse in the last 10 years of the Washington Consensus. And the Washington Consensus is the idea that free trade is a universal good. Everyone should want free trade. And that free trade would lift all boats, right? So it's a very conceptually a progressive project whereby development goals would be met by free trade, right? That concept, that consensus has all but collapsed in current rhetoric, right? Tell me one nation that thinks, we don't care where our investment goes. We don't care why it's going there. It's all good. Not anymore, right? And I think that collapse, really, you can look at kind of, a confluence of events, but the end of the Trans-Pacific Partnership, or the United States participation in the Trans-Pacific Partnership, was really part of that. So that's the first crisis. So that religion, that kind of, we believe in free trade. Now you'll see how that impacts privity, right? We don't care who comes, we just want it all, right? That's why there's pressure on that. And the second thing that's really created the crisis, or is precipitating the end, is the idea that I think parochial and domestic judiciaries have kind of put into the environment, no pun intended, that their domestic courts should be handling it. So it's a pushback. It's almost kind of like a Calvo-esque concept that our courts can handle this, right? And then that becomes a narrative about supranational secret courts and all that, frankly, nonsense, right? So those two things, the jealousy of domestic courts and this kind of resurgence of Calvo, and the collapse of the Washington Consensus, means crisis is too soon. We're beyond crisis. Crisis was 2017, 2018. we're in the death rattle. We're in the Gotterdammerung of ISDS without privity.
So I want Analia and Ladan to comment on that. Just a bit of a reaction to Patrick. And I think both of your points about the collapse of the Washington Consensus, which I think goes to much broader issues than just ISDS. ISDS is just a part of that. And this Calvo clause type pushback, and for those of you who may not know about Calvo clauses, this is the idea of states applying a form of national treatment in that investors can only receive the best local law treatment, not an international standard per se. So a treaty like an ISDS treaty that provides international standards would go against a Calvo clause, which was adopted by many countries, and I think really became less popular in the early 1990s. But you know, the return to Calvo, so to speak, may be in our future. So let me ask Ladan, what do you think? Crisis? No crisis? Something else?
Well, I'm just going to make it maybe a little bit simpler than Patrick. And maybe I'll just talk about why there could be a crisis. And I don't know if I'd go as far as you, Patrick, to say that this is the end of it, because in my dealings, at least with a lot of countries, I don't see it ending. You're right, maybe treaty-based, but even that, I'm not sure. So for those of you who don't know that much about ISDS, which I don't know, there are many of you out there, I think the crisis is really about the ISDS system. So the treaties in itself, they're protectionist treaties. They don't really regulate, they protect investments. They don't do anything else. And it's the ISDS system, how to, if there's a dispute that arises, what to do at that point. So the ISDS, one, is imbalanced. It empowers only foreign investors to bring a claim against a government, a sovereign government, but no one can bring a claim against the investor in the same forum, relying on international standards to have the matter resolved by international tribunals. So it's fundamentally imbalanced. The process is unfair. It's unfair, especially, let's say, for communities. And Toby Landau, in his remarks there, he was, I think that's the one you're talking about. He was commenting after showing a documentary called The Tribunal, which we co-produced with a director. It's about the aftermath of Copper Mesa. Oh, yeah, David, you've seen that too. Copper Mesa and what happens to these communities. And so I think it's unfair, especially for these communities of landowners that are affected by these projects and these disputes. And so what about their investments in their land and the production on their lands, these farmings and other kind of productions? So those are investments too. And besides, these are landowners. So their lands are being affected by these projects and these disputes. So if you have an interest in the dispute, they should have the right to be represented in these ISDS processes. I don't know if they really want to be, but they have no standing. So the foreign investor gets to bring a claim, but everyone else's interests are subsumed within the interest of the country as a whole, as represented by the national government. And that might not necessarily take into account the community's interests, for example. So, and we know, so I just think that process is unfair. And we all know what happens to awards that come out of unfair processes in law. If the process is unfair, the outcome is null. And it's meaningless, it's worthless, but it's not worthless in ISDS. These awards, which sometimes are millions or billions of dollars, can be enforced almost everywhere in the world. So it's not worthless. Third, I think it's really disrespectful of the host country's domestic institutions, and this goes to what Patrick was saying. Investors are not required to go through the country's courts and tribunals before going to ISDS, which is a departure from how international law normally works, customary international law, which really undermines and delegitimizes the national legal institutions of these host countries. So originally, ISDS was justified by claiming that the courts and the institutions in developing countries, newly decolonized nations in the global south, were unreliable or corrupt. But this is kind of now outdated. And we still hear it all the time. And it really implies that global South legal systems are inherently inferior, reinforcing this colonial era narrative and power structures where international institutions that are propped by the West are going to override local governance in these countries. And this is also discriminatory against domestic businesses in these countries who have to follow the national laws, and that foreign investors don't necessarily have, well, they do, but they enjoy this privileged access to this justice system that no one else has. And then to go back to, I don't really want to go into this eroding the state sovereignty and their right to regulate, because we've heard about that, and creating regulatory chill, which we've also heard about. And then I think that, you know, contrary to conventional views that this is propping rule of law and democracy and all that, I think ISDS is just undemocratic. So investors are bringing these claims to challenge sovereign regulations before private arbitration panels that are unaccountable to the public. They're not independent in the manner of a court. They're not called judges for a reason. They don't have the safeguards of judicial independence that judges have in the court systems that we know of. So as a result, they're not reliably independent from the perspective of those that are affected by their decision and from the perspective of the public. They're not bound by democratic principles and public oversight, yet they make these binding decisions, sometimes billions of dollars, that can override national policies that affect millions of people. So let's not pretend that it's fair. Let's not pretend that it's respectful of a country's democratic institutions, and let's not pretend that it's balanced and independent. And I think that's why there's this crisis of ISDS, and I'll leave it there.
Well, thanks, LaDon. You've done a great job in throwing a bunch of great issues into the mix, and I think we'll come back to them, but I wanted to give Analia a chance to address our macro topic again. What's your view of the crisis?
Thank you so much, and it's a great pleasure to be here today. I did my LLM here like 20-something years ago, and it's a great pleasure to be back at GW. Thank you so much to the organizers. So, I mean, if you take a look at what's going on and what has happened in the last years, like having states withdrawing from bilateral investment treaties or multilateral treaties, or terminating treaties, not ratifying treaties. I mean, the answer on whether, like, is there a crisis? Like, of course, there is a crisis. That's it's known that there is a crisis, and there are several issues that have led, or situations that have led to this crisis by the participants of the ISDS system. Ladar and Patrick and you have mentioned some of these strongest criticism. You just mentioned one, the regulatory chill, and just wanted to put an example of that. I had the pleasure of, or the honor, I could say, of representing many years ago Uruguay in the Philip Morris versus Uruguay case. And, you know, for those of you that might not be familiar with that dispute, the government of Uruguay back in 2009 issued some regulations regarding the packaging of the cigarettes. Basically two main regulations. One was augmenting the size of the advertising on the packages from 50% to 80%. I'm talking about these pictures on the packages of cigarettes. And the other measure was the single presentation, which was that for every brand for every sub-brand of the brand of Marlboro, Uruguay found that there was evidence, scientific evidence that all cigarettes cause the same damage, right? So there was not such a thing of a full flavor cigarette that was more harmful than a light cigarette, for example. So it required, the measure required all the tobacco companies in Uruguay to withdraw from the markets the packages of cigarettes that were a sub-variant. So for example, for Marlboro, Philip Morris had to withdraw from the market Marlboro Light, Marlboro Mint, etc., and only sell one to avoid giving the impression to a consumer that two packages of cigarettes were less harmful, that one package less harmful than the other. So Philip Morris sued Uruguay under the Switzerland-Uruguay bilateral investment treaty, arguing that these two measures violated the protections under the treaty, specifically, that the measures were arbitrary, that there was not evidence that those measures were going to reduce the consumption of tobacco, and expropriation, right? That I don't have enough room in the package to for the trademark for the Marlboro logo. So, I'm withdrawing these packages from the market, cause damages. And there was this, this is related to some of the issues that you have discussed. The tribunal, the right to regulate was a big issue that was discussed during this arbitration, the right of the investor versus the right of the state to regulate for issues of public health. And one of the effects that while this arbitration was ongoing, Uruguay had a president back then that was an oncologist, and was Uruguay very advanced on the tobacco measures to try to regulate the consumption of tobacco. And it has the regulatory chill, like some countries such as Costa Rica, New Zealand, waited to see what was going on, what was going to be the result of the Philip Morris case, to advance in their legislation and to see if they were going to issue similar regulations. And that was one of the effects that these, an example of this regulatory chill that ISDS may have on the investor state arbitration. And the tribunal found that there are certain issues such as environment or health in this case, where the tribunals, the states should have the right to regulate, and without violating the rights of investors when it is for the protection of these interests, such as environment or public health, etc. And you can see that as also after that case, and in the last years, there is the new generation of treaties where they have carve-outs, in these treaties, where now the states may be tired of the expansion of the interpretation of the protections that were negotiated back in the 90s, in the first generation of treaties. Some of them, such as concepts of fair and equitable treatment, were not very specific on what does it mean, or what does it mean for indirect expropriation, etc. So tired of being in cases where the tribunal expanded the interpretation, decided to go ahead, renegotiate the treaties to include carve-outs for measures related to public health, environment, or include annexes. For example, you have the CETA agreement or CPTPP, where have annexes clarifying what does it mean, indirect expropriation, or specifically that measures that are non-discriminatory and that have a legitimate goal of protecting the environment or public health should not be considered indirect expropriation, or such measures will not frustrate, for example, the legitimate expectations of an investor if these are measures for the protection of environment or public health. So I think there is a crisis. There are several examples of why this crisis exists, but I do consider that the solution is not to do away with the system, but just to repair it. And there are several ways of how to repair the system.
Well, and that's a great segue to where I want to go next. Then is you've talked about the idea of reinforcing in treaties, and we see this in new model treaties, the idea of making sure that there is the policy space for governments to deal with health issues like the Uruguay cigarette case, and environment and other related public policy directions of government. And we've seen that, and tribunals appear to be taking that to heart, but some debate on that. But I see that Patrick is itching to dive in on this topic, but happy to pass it on to you.
I mean, if you had a question to prompt me, that's fine. Otherwise,
No, go ahead.
So 4 quick points in reaction. One, Analia did such a great job in representing Uruguay in a non-recalibrated bit that Uruguay was permitted to maintain its regulation. So in this old 1990s style BIT with Switzerland, it still worked, right? There is no Marlboro Chevron on packages of cigarettes in Uruguay. And the same is true in Australia and in other areas. The fact that states had the option of terminating their bilateral investment treaties or recalibrating them and putting in for greater certainty language that health and regulation can be maintained, they chose to recalibrate and not to terminate. So the thought that this is a north-south colonial imposition itself, to me, smacks of elitism, because we should allow, as a fact, there's plenty of South-South treaties that exist between countries to promote and encourage investment. And in the Westphalian international law system, all states are equal, and they could have terminated these bits, but they decided not to. So if we don't believe that they were given undue pressure, then we believe that they're a state. They decided not to terminate this. So they believe, states believe, that there is some value. Some states don't. South Africa withdrew from all its bits, right? But Latin American countries still are maintaining them. We could take the position that that's because the North, the so-called global North or the G30 are pressuring them to maintain these bilateral investment treaties, but I think that itself is a little bit problematic as a position to take. Second point, without ISDS, right? Remember, I said treaty-based arbitration is going because this open offer without privity, right? You don't know who the investor is, you just say, sue me, right? That will go away. So what does that mean? That doesn't mean that Philip Morris won't have an agreement with a country as to what protections it gets for investing its product there. All it means is that small and medium enterprises, startups, female-owned businesses that are kind of got seed money from the World Bank, they won't have ISDS protection. They won't have protections that go beyond what the domestic judiciary offers, right? That might be fine. They might want to go to a difficult jurisdiction, Kazakhstan, someplace else that has sometimes difficulties in handling new investments, right? They might want to go there regardless, or they might not. But you know who's going to be able to negotiate an investment agreement with them? A big oil company. Because that jurisdiction really wants that investment. They really do. So there won't be a treaty necessarily. In fact, what that means is that the negotiation between, for example, the United States and Kazakhstan, where the United States is balancing equities, including, in previous administrations, environmental concerns, right? I was in the Obama State Department. We didn't just negotiate for Exxon. We negotiated balancing all sorts of equities, right? The current chief of investment arbitration is sitting in the audience. When he, not that the United States is negotiating bilateral investment treaties right now, but when we negotiate a treaty, EPA's at the table. Labor's at the table. We balance those equities, right? Without those treaties, state to state, what you have is Exxon deciding what it needs from the state in order to put its investment there. Okay, you can think about which would potentially be more progressive. Second point, or third point is, here's what happens when there's no investment treaty. A US investor when I was at the State Department, a US investor would call me, right, and say, hey, we've got an issue. This country is impacting us in a negative way. Sometimes that's, they took my house, they took my small hotel, right? It's not, they took my oil rig. It's always, they're hurting me. They've, a local police officer did X, Y, and Z. The first thing I would do as chief right, would be to look to see if there was a bilateral investment treaty. If there was, I would say you have a process. It's a rule of law-based process. Use the treaty. We're happy to connect you, but use the treaty. Without a treaty, this is what I did. All right, I'm going to call the embassy. We're going to demarche them. We're going to go down. We're going to talk to the attorney general. This cannot stand, blah, blah, blah. Full weight of the United States. Now, imagine what would happen if a US investor got in trouble in the Czech Republic. Without a rule of law-based system, who do you think gets on the phone and screams at them? From the Oval. ISDS is a rule of law-based system, okay? Second thing, the fourth thing is the roots of it. The roots of it, if you go back and read Ken Vendevel's book, is in friendship, commerce, and navigation treaties. The FCN treaties, which are meant to establish trade links with other countries. That's the basis of it. And it has progressive roots. The non-privity-based system has resulted in states feeling kind of, the non-privity-based aspect of it has resulted in states having some kind of outliers, I would say. But it's a progressive system in that it's meant to connect economies that otherwise wouldn't trade with one another with kind of basic protections. Most of the protections, most of the disciplines that are provided in investment treaties are already customary international law, right? Expropriation without compensation, et cetera. So I think that it's got, and I'll shut up in a second, Ian. It's got progressive roots is the fourth point. And I'll leave it there.
So I think you brought up a few issues, which is definitely added on to LaDon's commentary. One issue I wanted to get to, and this goes to the question that was asked at the end of the last panel, is this about the procedure? Is this about the choice of international commercial arbitration as a model that makes this unfair in LaDon's characterization? And the Copper Mesa movie was shown Toby Landau's speech, and he very much in his speech kind of channeled the dramatic and tragic nature that surrounds some of these cases. And a lot of those facts don't relate to the arbitrations themselves. It relates to the collision between extractive industries and local communities and so forth. But let's stick to our topic. What could we do better? And I know Toby had a few suggestions, and I'm happy to speak for him, but I'll let LaDon speak. Elaborate on that. If it's unfair, can we make it fair? Is it possible to make it fair?
I mean, we hadn't planned on that question, so.
Well, brought it up. It's unfair. Well, I'll give you a
Yeah,
little bit more.
okay, no, I
I
mean,
can give you a bit more lead in.
no. I mean, I'm happy to do it, but I just don't want to veer out of our, but it's okay. So how to make our treaties or how to make, because I do see them
process.
quite different. Yeah, so the process. I mean, I think my issue is these treaties, including the substantive obligations that are in them and how the process is going. Do I think that, if we replace the arbitration system with a court system with judges, is that going to be better? It might be, but we might have to also work on the other substantive content. So, fair and equitable treatment and all of that. So I don't necessarily know if I would go that route. I don't think it would, especially the way that UNCITRAL is going right now. I don't see any hope in the court system. So I wouldn't say that. I think one issue with what we're talking about is that I see investment treaties as really a barrier to effective governance. And I want to bring it to what's happening here right now. And I think one of the most troubling aspects of the regime is its impact on policy space that we've been talking about, and the ability of governments to enact and revise and enforce laws and regulations in the public interest. And I'm not just talking about environments, but anything, uh, including the environments. And so international investment treaties are increasingly being used against this effective governance. And let's say there's a hypothetical, let's say there's a new sheriff in town who swiftly pushes through a wave of new laws, but instead of going through the usual democratic processes that have evolved over decades, such as legislative debates, public consultations, judicial oversight, these laws are enacted unilaterally through executive orders. And then to further consolidate power, let's imagine that the leader establishes a fabricated government department, let's call it the Department of Government Efficiency, who operates without accountability, bypassing established legal frameworks and checks and balances. And this new leader and his friends pass a bunch of laws, a mining law without environmental assessments, a polluters freedom law where, allows industries to self-regulate pollution levels, make plastic straws great again law, a new charter cities. Let's say they do all of this, and this happens. It's not just here. It happens in a lot of countries. And then a new government comes into power and wants to fix all of that. But now they're faced with a bunch of ISDS claims using these treaties because they can use them. And it really strikes at effective governance. Like, what do we call rule of law and effective governance? I think that we're sort of seeing it upside down sometimes when we say this is a rule of law based order. And I think it is quite ironic that, the EU is out completely among each other. The US and Canada have eliminated ISDS between each other, and it was because of their sovereign right to regulate. The EU is about climate change and the supremacy of EU law, but they still keep these. And I think, I know that in theory they're reciprocal in nature. No one's putting a gun. I don't know. Maybe they are, but I work a lot with developing countries. They do get pressured a lot to sign these agreements. It's not as friendly as one might think. One particular African country that we've worked with, they said that, we've been trying to avoid signing a treaty with so-and-so country for the past 25 years. We have the most investors from that country in here. We don't understand why we need a treaty, but they keep saying that we need to protect these investors. So to go back to, is it promoting investments? I don't think so. It's really about protecting these investments. And I'm not saying let's not protect these investments. I think we need private investments, especially for the energy transition, for a whole bunch of stuff, that the trillions of dollars that you were talking about in private. So there needs to be some sort of a dispute resolution mechanism. Is it ISDS? Is it treaty-based? No, I can see Patrick's idea that contract-based ISDS is not necessarily going to be any better. At least you know who you're dealing with. But yeah, if you're dealing with Exxon, it might not be the greatest. So yeah, I don't know if I really answered, but I don't know if, I don't have an answer, basically. I just want to poo-poo ISDS.
If I was to synthesize, I think, where you're coming from, you don't think changing the system, the procedural rules is going to have a positive effect. This is a much more systemic macro issue, which I think the middle ground position, and this is the Topo Landau position, is that, because of the commercial arbitration model, it kind of focuses the arbitrators in a certain way, which excludes a lot of the political dynamic and the community dynamic. And I think part of his suggestion is that we need a better way of bringing in those views and accounting for them. And there's been a critique recently, of course, by a number of commentators, and we've seen this in a case in the English courts, the P&ID Nigeria case, where it is suggesting a much more active role on behalf of arbitrators as a way of kind of counteracting this arbitral tunnel vision, which Toby Landau suggested. But Analia, you're a master at international arbitration procedure. Do you think there's something we can do, or do we need to go to a court, for instance? Is a court the way to go? And I say this because there are many folks who think we should go to a court model as opposed to an arbitration model.
Yes. Well, first of all, what I think that, of course, if you want to incentivize investment and if the countries want to have investment, they need to offer investors a dispute settlement mechanism that is something else that ending in domestic courts, right? Just that to begin with. Because otherwise, I don't know, as I mentioned, I focus my practice a lot in Latin America. I recently traveled to 2 countries where, usually, of course, I meet with the government, and I also meet with law firms right there and that advise for investors. And for example, in Mexico, considering what's going on right now with there's going to be a reform of the judicial system where the judges at all levels are going to be elected by, so of course the investors are worried of, they don't want to end up in court in Mexico, and that's why even law firms sometimes tell me, like, I'm advising my clients against Mexico City as the seat of the arbitration, just because you don't know what is going to happen. So, but again, I think that the solution is not to do away with the system, but to repair the system. And there has been in the last years already, like ICSID has modified their rules. UNCITRAL, of course, the group 3, working group 3 is also suggesting some changes and modifications, and even like treaties, just as CETA, includes the solution of a court. I think that there are several things that can be done. For example, like even in the treaties, you can, in order to protect the environment or public health, you can incorporate for example, in the definition of investment, that the investment has to be in accordance with sustainable development, or like even you have the legality clause that, the investment has to be done in accordance with domestic laws. Well, you can be more specific with respect to environmental laws that need complying. Otherwise, the investor will not have access to an investment treaty system. I think that, of course, there are other things that can be. TMEC also includes these provisions where they incorporate, the system is available. The TMEC is the new US, the new NAFTA, but the system is available, but you need to exhaust local remedies and the system before going to arbitration. And you also have certain industries where ISDS is available, and others where it is more difficult perhaps to go to arbitration. But I think that the states are trying to react to this criticism. There has been changes there is a new generation of treaties. And I think that, of course, there's going to take some time to see if the changes that have been implemented in the new generation of treaties will resolve some of the criticism that of ISDS. But again, I think that you, of course, need to offer. I still think it is good to have bilateral investment treaties and to offer the investor the possibility of an impartial tribunal to resolve the dispute. So there's still things that can be done.
Well, and on that point, and I'll lob a question at Patrick, because I know this is one of his favorite topics. As Analia mentioned, there's been efforts, certainly by various institutions at the World Bank, as well as at UNCITRAL, the UN Commission for International Trade Law. It has a working group 3, which has been working for, I don't know, how many years now? 7 years? Just almost 10. And I know Patrick has he was still at the State Department when that process was being contemplated. A lot of procedural reform has been worked on. ICSID put out its new rules 1.5 years ago. There's stuff being worked on at Working Group 3. Is this enough? Do we need to do more? And what is that more?
Yeah, well, I mean, Toby has a point on the kind of incongruent the kind of, it doesn't fit well to put commercial arbitration procedures on top of investment treaty procedures, because in a lot of senses, there's public equities at stake, and that needs to be taken into account. So what ISDS has done over the last 20 years now, but it's really been focused in the last 10 years, is include provisions and changes that are meant to be responsive to some of the valid criticisms that have been leveled against it, right? So I don't know of any investment treaty arbitration that is not open to the public. You don't see big oil company number 1 versus big oil company number 2 ICC arbitration. You have no idea what's going on there. And let me tell you what, the result of that also impacts the public. But you don't see that. You do see it in investment treaty arbitration. And every hearing that I've ever done on an investment treaty arbitration is open to the public and live streamed. Live streamed. You know how many people watch those live streams? It's like 4. Like 2 of them are my friends. One of them is my aunt commenting on my tie, right? And then about 17,000 dummy, IP addresses in China. But the reality is no one cares about these, no one watches these things unless they do, and that's good, right? So transparency. Another thing, amicus submissions. Big oil company number 1 versus big oil company number 2 at the ICC. Greenpeace can't submit an amicus brief explaining the environmental impacts about the resolution of this contract claim. In ISDS, you can. In fact, they do a lot. Almost every environmental related regulation that is under scrutiny in ISDS includes submissions from third parties who have an interest in it, including local populations, et cetera. That's good, right? That's an innovation, I think, meant to kind of respond to some of these critiques. Third, you don't want people like me or people who make their money defending these claims or prosecuting these claims sitting as arbitrators. Double hatting. There's a question about competency. You do want people who understand public international law and are at the absolute height of their career to sit in judgment of these things because there's a competency issue. But often, and in greater numbers, the judges, the arbitrators, don't also sit as counsel, right? That is far different than ICC arbitration, where counsel sits as arbitrator all the time. So the club, the so-called club, is really broken in ISDS because we all know who sits and when. So those are some of the kind of procedural innovations that have occurred. But the only other point I will make is just a kind of a macro point about development. When I was a diplomat, we would hear all the time from folks saying they want ISDS, notwithstanding the criticisms, because it helps them open up their regulatory regime. We heard it in Mexico. One of the reasons why the USMCA, everyone was comfortable in the USMCA at putting in a local remedies requirement was because the difference between the regulatory state in Mexico in 1992 and the regulatory state in Mexico in 2022 was vastly different. And you know what? Mexican diplomats, including under AMLO, credited the NAFTA, Chapter 11, for giving them that. So it allows states to reform their regulatory state in a more transparent, more APA kind of way. And I think that that's important. And then the last thing is, leaving aside the Washington consensus, I still think we all still believe that states that have a lot of trade with one another don't kill each other. I hope that's true still. So we want to encourage that kind of trade, whether it's through an FCN or bilateral investment treaty or something that's hortatory, right? We do still want that trade. And if that African state and another state pressuring it, if there's investment without it, great. I'm not sure why the state's pressuring it. I'd be curious to know which global north state is pressuring it, because I don't know any global north states that are negotiating treaties like this. The last one that was negotiated was Egypt-Saudi. That's it. The last one the United States negotiated over 10 years ago, Rwanda. Okay, thanks, Ian.
So I'm just going to respond. Sorry, Ian. Well, Canada just signed a FTA with Ecuador, which is unconstitutional. So our great Canadian background there, Ian. So I don't know if it's fully been signed and ratified, but it is unconstitutional under Ecuadorian law, but they did it anyways. Canada is very heavy on negotiating these ones. The US isn't, so we're sitting in the US, and the US hasn't been doing it. But European countries do, and so do a lot of Asian ones. But I just wanted to make 2 points. Your procedural innovations, and I don't want to be reactive to what you were saying, but you know, I study these procedural things about, especially these amicus submissions. These amicus submissions are very difficult to get accepted. They're not automatically accepted into ISDS proceedings. When they are accepted, you're limited to about like 10 pages, and they tell you exactly what you have to talk about. You can't see the documents that are, you know, exhibits and everything. You can see maybe the pleadings. And then you're not talking about your rights or interests. You're sort of trying to give a different perspective to the tribunal, a third party, sort of a neutral one. These amicus, especially when they're coming from communities, they don't have resources to bring, you know, to hire a legal counsel to do this. Organizations like where I work, we might do it. It takes a lot of our resources, and we don't have funding for it. So it doesn't really have, anyways, they don't really have an effect. I've written about this, and arbitrators talk about this, and in their decisions, they sort of say, yeah, they said this, but whatever. It's not about human rights. This is about compensation. This was indirectly expropriated, and it's not. About transparency. So oil versus oil in the ICC, I mean, I think that's a bit different, and maybe I don't know what you're talking about there, but we're talking about oil versus states here, and the state includes the public. And so I think that it being transparent is a bit different, because it is the taxpayers' money that's being that's going to fund these claims and these awards. So I think it's a little bit different. And I don't know if transparency really, if we have a very, very transparent system, if that's going to fix everything. I still think that there are other issues, not just the procedural ones that we've been talking about, but the substantive ones that, and just the underlying premise of these treaties, that you're giving these privileged you know, group of investors this parallel justice system, a right to sue a sovereign country.
Well, I think we could go on as well, but if we have a couple of minutes, I know we started a few minutes late, 10 minutes late. Do we have any time for question? Maybe one question, two questions? I am, you know, hazard being the person between you and your lunch, but questions? Anybody want to jump into the discussion? At least one or two? Yeah, I can hear the stomachs rumbling. Well, we can stop it there and continue the discussion over lunch. I know everyone on the panel here is always happy to discuss their favorite topics. So I guess with that, I'd like to thank our panelists for an engaging take on the crisis in ISDS. And we'll talk with everyone over lunch. And so thank you.